Hello, everyone, and welcome to this month's webinar, 2024 Mid-Year Compliance Review, Understanding Employer Obligations. This specially formatted free webinar is available exclusively for all WorkWise compliance customers. I'm Stephanie Blicky, the Product Operations Manager for WorkWise Compliance, formerly Personnel Concepts. I'm joined by my co-moderator, Dan Hilfrich, who serves as our Senior Human Resources Manager here at WorkWise Compliance.
Hey everyone, for today's webinar, we'll discuss various new employment laws currently in effect in 2024 or set to go in effect very soon. After a brief discussion, you can consult with our guest attorney on these critical updates in our live Q&A session.
That's right. So today's webinar will explore the following topics and any new employer obligations created under recent legislation. So we'll talk about general labor law topics such as fine increases and the recent ban on non-compete agreements, wage and hour rules involving new overtime rule provisions and preventing worker misclassification. We'll also talk about workplace safety obligations, including the final rule on employee representation during OSHA inspections and a restructure of OSHA's regional operations. We'll also cover harassment and discrimination updates, such as a recent ruling by the Supreme Court involving the use of significant harm in Title VII cases. And then we'll also talk about other recent updates, and we'll wrap up the discussion with 2024 minimum wage increases. And then in the final moments of our webinar, our guest attorney will answer some audience questions live, providing you with an invaluable experience of engaging with a legal expert on critical issues. Our speaker will also offer key takeaways from today's session while we engage the audience with poll questions throughout.
All right, and speaking of engaging poll questions, let's get started with our first one. Today's webinar session is heavily dependent on audience participation. So to make the best use of everybody's time, we're searching for timely and meaningful questions to present to our guest speaker. So to ensure that we're prepared to fulfill today's hour with helpful content, we need to know, what are you most interested in hearing about today? General labor law topics, wage and hour rules, workplace safety obligations, or harassment and discrimination updates? Please select all that apply. I'll give you a few more moments to answer here. All right, and it looks like based on the results, everybody seems the most interested in general labor law topics. So we'll try to take a little bit more time covering that information today. Thank you so much to everyone who responded.
Yeah, thanks a bunch. So, and as your Q&A session co-moderator, I'll direct any audience questions to our guest speaker. Just keep in mind that your questions may be slightly modified to ensure the best outcome for the session. The purpose of this webinar is to provide accurate and authoritative information on the subject matter being discussed. It does not constitute legal advice. The applicability of the tips and laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel and your human resource professionals on specific matters pertaining to your business. WorkWise Compliance, the webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law or advice that lead to unfavorable outcomes.
All right, and in today's webinar, we're hosting a special guest attorney to cover the importance of staying informed about recent updates to the ever-changing employment law landscape. Our panelist has frequently acted as a guest speaker in our past webinars, and I'd like to welcome back Attorney Jeff Fucci. Jeff is a graduate from Vermont Law School and is the founder, CEO, and lead attorney of the business consulting firm J. Fucci Law, LLC. At that firm, he serves as a trusted business advisor, consultant, and in-house counsel for various businesses ranging from startups to large corporations. Before establishing J. Fucci Law, Jeff gained valuable legal experience working at big law firms in the New York metro area, serving as a judicial law clerk across the Hudson River in New Jersey, and serving as an adjunct law professor at Seton Hall University, where he attended undergraduate and graduate schools before earning his JD. Welcome, Jeff.
Well, thank you, and thank you for having me, Dan and Stephanie. It's good to be back. As you know, a lot of my business clients are entrepreneurs and managers in various industries. I offer my services in counseling them on labor disputes, employment negotiations, anti-discrimination and other workplace policies, contracts, federal, state, and local governmental regulations that affect their business. Knowing about changes and additions to the employment law landscape are extremely important for all businesses, and I'm looking forward personally to discussing mid-year labor law changes with all of you gathered today.
Thanks, Jeff. And before we proceed, we just want to ensure that everyone can hear and see Jeff clearly. If you have audio issues, check the volume on your computer or mobile device. If that doesn't solve the problem, just let us know in the chat and we'll work to improve the audio as best we can.
All right, and before we begin, WorkWise Compliance is offering all of our attendees our 2024 Mid-Year Employment Laws Update e-guide. This resource includes more information about the topics we'll discuss today, including important links to agency news releases and full versions of regulatory text and guidance. As an attendee, you'll also receive 2024 Minimum Wage Map, which includes minimum wage information for states with recent changes. Also provided to attendees in today's slide presentation, which is equipped for note-taking. All of these resources are attached as handouts here in GoToWebinar. At the end of the session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone to submit any questions you may have during the presentation by using the Ask Questions feature in GoToWebinar. You can also post questions in the chat window. Most questions will be saved for the end of today's session, but those relevant to the discussed topics may be posed where appropriate. With that, let's get started with today's session. Jeff, let's start off with some general labor law updates.
Sure, Dan, sure thing. Well, in January of 2024, the U.S. Department of Labor, which we'll refer to sometimes today as the DOL, made civil monetary penalty adjustments for the year 2024. Now, it wasn't just the DOL who made these changes, but pretty much all U.S. government agencies taking effect around the same time. This is called the Federal Civil Penalties Inflation Adjustment Act, or maybe just known as the Inflation Adjustment Act. And it provides a cost of living formula for annual adjustments to civil monetary penalties related to the labor law industry, usually taking effect in mid-January, but sometimes also taking effect, as we'll talk about today, around July 1st in the middle of the year. Now, generally, the adjustments cover several penalties for violations of labor laws that apply to a wide range of employers and a wide range of industries. The violations and adjustments to civil monetary penalties that affect these businesses that are maybe the most valuable to everybody who's gathered here with us today include penalties for violations of some of these laws. Violations of the Employee Polygraph Protection Act, violations of the Child Labor Standards sections of the Fair Labor Standards Act, or the FLSA, which we'll also talk about. It'll be a reappearing guest today several times in our talk. Willful violations of the Family and Medical Leave Act and its posting requirements, and penalties for violating certain sections of the Occupational Safety and Health Act. Now, that's also called the OSHA Act, and that's where we get OSHA, which we'll hear about a little bit more today as well. There's something in there called the General Duty Clause, and again, that has to do with posting requirements. So as you'll see as a repeating theme, a lot of the raises of the civil penalties that have gone up from the federal government, they relate to posters in the workplace, which is a really great segue into the work that our group that's here today does on WorkWise side, because having posters that are up to date and applicable in your workplace and a public area, that can be very important. And failing to do that, I see Stephanie's got a poster there behind her, that can be very expensive. So.
Thanks, Jeff. Since this is an annual adjustment, it's just always good for employers to have it on their radar. Also, some businesses may have multiple locations, so the fines may seem small, but they can really start to add up. Here at WorkWise Compliance, we're confident that our products and resources will help protect you from those regulatory fines. However, if you ever do get hit with a fine, we do offer that we pay the fine guarantee, offering reimbursement starting at $40,000. So for more information, just contact us at WorkWise Compliance Customer Service Representative. We'll put the chat number in the window there, or in the chat right there. So you'll have the phone number for us. What other general labor law updates do our customers need to know about, Jeff?
That's great, Stephanie. We'll start with the big one. And just this week, I've been doing the beginnings of what I hope will keep me busy in the fall, but might be a pain in the neck for employers. And this is the FTC's new rule banning non-compete agreements nationwide. I've already begun auditing the contracts, asking the questions, because this rule's full implication is right around the corner. So what does the rule do? Well, the FTC is the Federal Trade Commission. They've got a lot of control over a lot of industries, a lot of regulatory oversight, and that's what kind of got them to a place where they passed this new rule against non-competes. The federal agency did a lot of policy-backed, data-backed rulemaking, which is part of the process under the Administrative Procedures Act that allows the agency to put together rules in the first place. It's also a way that they hope the rule can stay defended against the court challenges which will come, which are inevitable. As we used to say in law school, night follows day, the way court challenges follow federal rules. So the agency cited extensive data, public feedback, and much reasoning for the rule, believing that this rule is going to promote competition, improve the national economy, and protect workers. Specifically, the FTC cites in its rulemaking basis that banning non-competes will result in more than 8,500 new American businesses created in the next year that couldn't get off the ground before. The FTC also estimates that the new rule will lower healthcare costs across the nation $194 billion over the next 10 years, and that the new rule will increase patents, that's protections of trade secrets and protections of processes for businesses that have IP, for a range of 17 to 29,000 patents more to be released per year for the next 10 years. Now, according to the FTC, approximately 1 in every 5 American workers are currently subject to some sort of non-compete agreement or agreement that has inside of it a non-compete clause, right? So we're not just talking about agreements that are called obviously and explicitly non-compete agreements right at the top there with the bolded text. That's not the only thing going on. A lot of agreements that are entered into by companies and their workers, their employees, or their independent contractors, these are also clauses. They're sections of agreements, and these sections might have to be reviewed by counsel and maybe changed or stricken out. We see a lot of non-competes for industries like science and technology. If anybody's working in the food sector, I did this with a client this week. You see a lot of them in places that deal with recipes or processes in the kitchen. Big fan of that movie Chef. They talk about using the cooking with the bags. I mean, that kind of thing gets protected by non-competes all the time. And although that might be expected to be the norm in those industries, the FTC, when doing its rulemaking, took a lot of public testimony from everybody really who could be affected. So we're talking about people that are in the inventive space of a workplace, but also entry-level and minimum wage workers. And all this testimony the FTC gathered basically said that people that were subject to non-competes in the workforce faced a lot of lawsuits and often couldn't get jobs and couldn't move themselves from one job to the other. So the new rule's intention is to lift these restrictions and nullify existing non-competes, both at the agreement level and the clause level, except for non-competes with a group of people called senior executives. And that's a legal term that's in this rule. And they define those people as workers that earn more than $151,164 annually and who have policymaking authority at the level of the entire business enterprise. Once the rule takes effect, employers are going to be required to notify their workers that non-compete agreements or clauses in regular agreements that they have in place are no longer effective. Basically, if an employee signed a non-compete agreement at the time of hire, and that time of hire was before the rule takes effect, that contract is going to be no longer binding. If they signed an agreement with a clause in it before the date of the rule taking effect, that clause is going to be non-binding. The FTC will continue to allow other types of agreements that protect employers' intellectual property and other legal concerns. And these would be the types of things we've heard of called non-disclosure agreements, aka NDAs, as well as agreements that cover trade secrets, copyright, patent, and other intellectual property laws that come out of the federal and the state governments. Now, what's the date for this rule? It's been in the works. People are talking about it. Like I said, I'm getting calls from my folks asking how to deal with it. The actual deadline for the rule to take effect is September 4th, 2024. Getting ahead of that rule, down in Texas, in the United States District Court for the Northern District of Texas, a business filed a lawsuit that was decided in early July this month. The court in the Northern District of Texas enjoined the FTC from enforcing and implementing its rule, banning non-competes, and stayed the September 4th effective date after a small company in Texas sued the FTC over the rule. This makes the future of the FTC's rule uncertain, but please note, everybody who's listening today, it's only uncertain in Texas. Other than Texas or any other courts where another ruling is later made, the rule is going to be effective and take effect on September 4th. So what's important about that, I'm staying on this topic for a minute because it's just so important. I'm getting so many questions. What's important about that is come September 4th, employers are going to have to reach out to their workforces and let them know that if they have non-compete agreements in place or non-compete clauses in place, they're no longer enforceable. That's actually also another requirement. Now, there's some language that WorkWise can help point you to. There's some models of ways of speaking. to the employees. I know there's a lot of questions coming from the various industries. How do I do this? What's compliant? They can give you some of that guidance, and they can draw some of that from the FTC. So do check back in as we approach September 4th, which is less than almost about a month, a little bit more than a month away. September 4th is a hard deadline for this rules compliance and enforcement across the US. So
That's a really thorough explanation, Jeff. What other general labor law updates should we know about?
yes, after that, everything's going to seem easy. But there's just two other subjects that I'd like to touch on as we stay in this section. As of March 20th of this year, 2024, employers and consumer reporting agencies, which could include actually third-party vendors that get hired by employers, they now have to provide a newly revised summary of consumer rights, that's the name of the document, to all applicants and employees when background checks are being conducted. This is to comply with the Federal Fair Credit Reporting Act, which businesses may have heard about, but probably all the humans who run businesses have heard about a little bit more because it comes up with things like our credit cards and our loans. We hear about it in that way as well. But FCRA also applies to certain business activities, and under the FCRA, employers must provide job candidates with something called the Summary of Consumer Rights, and that must come along with a copy of the applicant's background check and something called a pre-adverse action notice. I'm going to tip it off again to Stephanie and Dan because the pre-adverse action notice is another thing that can be something that WorkWise can help provide a draft, and some of that draws from the federal agency's guidance. It has to warn basically that an adverse employment decision, which is a negative decision that could affect the employee's job conditions, and that could also include whether they get hired or not at the very early stage, that kind of decision can be based upon the results of the background check. So really it's kind of a understand your rights if you consent to this background check. So this can occur when an employee applies for a job and they're denied because of their background check results. And what this updated version of the document coming out of the government does is it fixes several technical errors. It changes a few addresses and a few contact numbers for the federal agencies, and it kind of lets people in the workforce know where to go if they have a grievance in terms of the governmental regulation. Now, in March, the California Court of Appeals lifted a year-long injunction on enforcing something called the California Privacy Rights Act. Now, other people may have heard, everybody gathered today, especially those with California knowledge, might have heard of the California Consumer Protection Act. It's a similar law. This is the California Privacy Rights Act. This applies actually to businesses as well as regular citizenry. So the CPRA applies to information gathered by human resources departments working for companies, and it applies to information gathered about job applicants, employees, independent contractors, and emergency contacts. Moving forward from the implementation of the CPRA, all affected companies with employees who are California residents will need to implement internal policies, procedures, and mechanisms that ensure compliance with how data is gathered from people in the job process, their workers, and how it's shared and if it's sold. This includes updating notices about required and permitted disclosures of personal information, the rights of owners concerning their own personal information, and the retention period by the folks that are gathering the information. The CPRA grants employees many of the same rights that we might have heard about with the California Consumer Protection Act and what it grants to regular old consumers. These rights include the right to know what personal information is being gathered about them or from them, the right to delete personal information, the right to non-discrimination based on that information, the right to retaliate, not to retaliation, but against retaliation for exercise of their protected rights, and the right to opt out of the sale of their personal information if that's going on. Businesses covered by the CPRA are those that do any of the following. So these are either or criteria, making this a broad protection covering many businesses. CPRA covers businesses that do business in California, which means sell anything to California consumers, control any inventory within the state of California, have any employees inside of the state of California, basically anything that a business might think about that generates revenue. If it goes on in California's borders, California is a big state, it's almost a whole coast. They could be subject to this CPRA. It also applies to any businesses that operate for profit, collect the personal information of California residents, or have a gross annual revenue exceeding $25 million in the preceding calendar year. These businesses that are subject to this rule must publish their policies on these topics on their websites, the same way that the other law, the one relating to consumers, requires businesses to publish information on their websites as well. Businesses should also work with their in-house legal counsel to review the agreements they've got in place with third-party vendors who may handle personal information on their behalves, and that's another topic covered by the rule. The California Privacy Protection Agency, that's a specially created subdivision of the California state government, they enforce this rule. It's expected to publish final implementation regulations for the CPRA later this year, so stay tuned. Maybe I'll be back, or maybe someone else will be back telling you how that all works on practical terms. And these regulations are expected to include requirements for certain businesses to perform cybersecurity audits, take risk assessments, and make sure that they're implementing the rights that the rule brings up in terms of access to information and opt out with respect to how businesses use information. And also where that affects automated decision-making technology, or AI, where that might come into play. We were talking a couple of days ago, the group gathered here, about a practical example. Of course, as we know, many businesses, as they scale, they're starting to bring in some of these AI resources in their hiring processes, where the AI is helping to look at the resumes, screen applicants, and things like that. And of course, one of the parts of that that's going on, and you'll want to pay attention, businesses, when you sign on with agreements, with terms and conditions with third-party people, vendors rather, that work with AI, you want to make sure that you're not, by way of signing those agreements, giving up the right to the folks who are applying's data and giving it over to the third-party companies, because you're going to have to watch there too, because that's going to be a liability that occurs under this new rule in California. So just pay attention to that. I know it can seem very enticing to hire all these AI bots to do what humans used to do, but you got to watch what you're signing away, because there's very strong protections in California.
Some great information, Jeff. I think this is an excellent time to give you a little breather and ask a poll question. Now that we've gone over some general labor law updates for 2024, we would like to know, which of the following would you like more information on? This could be provided in an e-guide or a standalone webinar. Would you like to know more about civil monetary fine increases, the legality of non-compete agreements, the Fair Credit Reporting Act and its summary, the California privacy law, or none of the above? You can select all that apply. We'll give everyone a few moments to answer. And just a reminder for everyone while you're answering, we will send a link to this video of this webinar later. So you will be able to go back and watch it and share it with your colleagues. So we'll go ahead and close this poll. Based on the results, it looks like there's a split around, but most people are interested in the Fair Credit Reporting Act and its summary, and the legality of non-compete agreements and clauses. So thanks to everyone who responded. This helps WorkWise Compliance create and provide the information just most important to our customers. Jeff, let's move on. I'm going to put it back to you here, to the recent wage and hour changes. What new laws do you think our audience needs to know about?
Sure thing, Stephanie. Thanks for that brief break there. I think I was getting tired of talking, and people might have needed a break from hearing me. So we'll go back now to the next stage. Earlier this month, there's two laws that I want to talk about as we go into this next area. And these are rules that have to do with overtime protections and worker misclassifications. And these are big topics that come up. And if those buzzwords don't get us there yet, we'll find out in a minute, because every employer faces these concerns that has a staff. Earlier this month, on July 1st, the salary and threshold exemption, which is part of how we determine whether overtime should be paid or not, that went up. And that occurred for the bona fide executive, administrative, and professional employees, and it increased to the equivalent of an annual salary of $43,888, up from a previous lower threshold. Broken down, this equals a salary of $844 per week, raised from what existed before for the week threshold. On January 1st, 2025, so stay tuned, the second threshold is going to be increased and take effect. The threshold is going to raise itself up to $58,656 per year in salary, or $1,128 per week in salary. The salary thresholds have been programmed to continue to go up every 3 years, and that'll start again beginning on July 1st, 2027. The Department of Labor has indicated that it believes that updating these amounts will regularly maintain the intended protections of the regulations with regard to overtime. Employers should follow these new overtime thresholds to comply fully with the FLSA. Now, earlier in May, back to Texas, which has got a lot of challenges coming out of it lately. Back in May, there were some lawsuits filed with the Texas District Court to try to stay the final overtime rule. In late June, a Texas District Court barred Texas government employers from having to follow the new overtime rule. But remember, as I said, jurisdictionally, that's just Texas. And even narrower than that, that's just government workers in a small part of Texas. Small part of a big state, maybe bigger than where I'm sometimes talking from in New Jersey, but it's still not everywhere. So the rule is still in effect for the rest of the nation, and businesses should try to ensure their compliance. And basically what's going on, just if those numbers were a little bit overwhelming, is the government has basically set up a mechanism where as the cost of living goes up and as inflation go up, the number at which a person's salary will make them not subject to the overtime requirements, that number is getting higher. So where employers used to think, well, because the salary is so high that they're out of me having to pay them overtime, and that's one of the criteria, what we see the federal government having done here is they've changed that. They've put it on a sliding scale. It's designed to meet the rising costs of our society. And it's set up now to continue that way for a long time. It could change depending on who's in the White House. It could change based on who's in charge of the agencies and who's really writing the laws, and then the laws that sometimes battle the other laws in Congress. But as of now, we have to expect that as the cost of things goes up, the salary threshold will go up in the next near bunch of years. And people that have higher salaries will now be included in overtime protections that used to go to people who only had salaries that were lower. So that's the takeaway. Still, I said it kind of wordy, but I tried to use language that makes it a little bit more clear. Just as the numbers of the salary goes up, expect to have to pay more overtime because that's going to be a cost. So it's something to look into. Now, going back a little bit in time to March of 2024 of this year, there's another important guidance decision that came out of the DOL, and this has to do with who's an employee versus who is an independent contractor. Huge question, comes up all the time, constantly answering it. As many people know, the Act, the FLSA, does not define the term independent contractor. It's not a statutory legal term. Instead, we rely upon many court cases that have been filed and many doctrines of law that have come out of various court decisions. This has led to a situation where many businesses worry about the legal term for the concern, which is called misclassification. Without a clear definition, it's been up to our nation's courts, and they've held that under the FLSA, the question is whether, as a matter of something called the economic reality of the situation, the worker involved is economically dependent or economically independent related to the company that's hired them to work. If the worker is economically dependent, they're likely an employee. Alternatively, if the worker is independent and in business for themselves, they are likely an independent contractor. It's important to note for anybody listening to us during this presentation that we're not just talking about independent contractors by name. A name sometimes doesn't cover every manner of situation. There's also other terms floating around like contractors, self-employed individuals, vendors, gig economy workers, and then freelancers. And all of these people are within the auspices of what might be considered an independent contractor. The misclassification of employees as independent contractors is a serious issue from the labor law perspective. Misclassification can result in workers being denied minimum wage, overtime pay, and other very important protections.
I'm going to give you a breather here, Jeff, and talk a little bit about my experience as an HR manager with misclassification. So I've had the opportunity to explore this a couple times in my career. And the reason being is having employees is expensive. You pay benefits, you pay FICA, payroll costs, there's unemployment charges. There are a lot of different costs associated with having an employee that aren't there with a contractor. So sometimes business owners, upper management may try to classify someone as a 1099 or a contractor just to save a little bit of money on those hidden costs of having employees. It's really a risk-reward kind of thing. I've always, obviously, in my role, advised to bring someone on as an employee if they wouldn't properly classify as an independent contractor. But it is a frustrating back and forth that's always going to be there. But it's important to consider the risk that you're bringing on, because it's not just one agency that is considering it a misclassification. There are a whole bunch of different parts, like you said, the minimum wage, and all the different parts, overtime, etc. So in the new final rule, how can employers determine the proper working relationship?
Well, Dan, you make a great point, and we'll get right into it. But just to say that the thing about it is, as a lawyer, I often advise businesses, my clients, I say to them, there's two things to go about here. There's how much money you can earn and how much money you can save from liability. And both of those things, in my role as an attorney for businesses, I tell them are equally important, because everybody wants to make money. And we understand that. That's fine. That's great. That's what business in our society is really for. But the cost of losing money can also be significant. And if you're only focused on making it but not worried about preventing losing it, your business could quickly bleed out a lot of cash. And so you make a great point. It is a cost benefit analysis, but understanding the legal world that we live in, the regulatory world, I think can really help them maybe get some data for making that cost benefit analysis. It's sometimes not worth the risks to get it wrong. So with that said, the courts have tried to help us out, and they've provided, and the agencies have tried to help us out, and they've provided a 6-factor test that can be run down by your HR folks or by your legal folks, and they go through the economic reality of the relationship between the worker and the company. And I'm going to stick to those words, worker and company, because we're trying to figure out, is it employer, employee, employer, or is it independent contractor company? So we'll say worker and company because we're going to use this test to figure out which one they are. So these are the factors that the businesses should try to consider in looking at the economic reality of the relationship that lies ahead of them with the worker. The opportunity for profit or loss depending on the worker's managerial skill set. Investments by the worker and the company made into the business of the company. The degree of permanence expected in the work relationship. The nature and the degree of control over the work performed. And this is where we get into stuff we've talked about in these presentations before. Who's providing the tools? Who's setting the schedule? Who's providing additional personnel resources? This is a tricky one because we're post-COVID, but is the worker home? Is the worker in an office? If the worker, is it substantial control? That's more towards employee. If it's pretty much, you're the expert on this, do your thing, it's more of an independent contractor. That's how that factor kind of works. The extent to which the work performed is an integral part of the company's business. Is this sort of a siloed, sort of project-based assignment? I see a lot of those independent contractor project assignment, project scope, or is this something that is essential to the management of the business? And then finally, the amount of specialized skill and initiative that the worker uses. That, for example, is something that would apply to, say, a specially trained person with a special license, somebody like myself, an attorney, an accountant, a engineer, but even people who has things in like specialized degrees in the art fields or in the creative fields. Those could be things that lean more towards independent contractor because that's kind of like you are your own business. You take it with you and you take it with you from job to job versus somebody who goes to a place and gets on the job training to do a very specific task. That's more like an employee. So I expand on those a little bit just to try to help employers understand that that's how they should expand and how they should ask those questions. So there's 6 factors. And that's it. And if employers have questions about the specific role or relationship when facing the worker company dynamic, they should look at this relationship, look at these factors, and try to use them as a guide.
Lots of great information, Jeff. Before we continue our discussion, I'd just like to ask the attendees another poll question just to determine how much time we should spend on an important topic. So we want to know, has the Occupational Safety and Health Administration, or OSHA, ever physically inspected your workplace? Yes, no, or I'm not sure. So we'll give everyone a moment to answer the poll. And just a reminder that you can start putting questions, submitting them now for Jeff to answer in our Q&A session. But we'll go ahead and close your poll here. So it looks like 59% have not been inspected by OSHA. That's great. 32% not sure, so maybe not your department, and 9% have. So you're well aware. So thanks so much for your responses. Jeff, can we go over what employers need to know about OSHA inspections and other workplace safety and health updates?
You got it, Stephanie. And it's great that we have a group that has experienced OSHA so that they can maybe benefit a little from understanding what's changing with OSHA. 2 significant changes involving OSHA have taken effect not that long ago. And first, the Department of Labor released a new final rule affecting OSHA. This rule took effect on May 31st, 2024, and the rule clarifies the rights of employees to select and authorize their own representative to accompany an OSHA compliance officer during inspection of their workplace. This is known in colloquial terms as the walk-around rule, and it builds upon some already existing law. Traditionally, the Occupational Safety and Health Act, which is OSHA's primary law, granted employers and employees the right to authorize representatives to accompany OSHA officials during a workplace inspection. Now, that's representatives of the employer, chosen by the employer, and a representative of the employee, chosen by the employee. Think about this in terms of if there's a workplace safety issue, it's going to affect a worker most likely, and the worker has had the right traditionally to have their own representative come through on that walk-around. Now, the walk-around rule clarifies some details about that right, and it adds some protocols for them to follow when the employee is choosing either a fellow employee or a non-employee to represent the employee's best interest during the OSHA walk-around visit. If the chosen representative is a non-employee, they must meet the reasonably necessary criteria test that's been put out there by OSHA based upon their skills, knowledge, or experience with similar hazards or conditions, either in that workplace or in similar workplaces. Or it could be based additionally on their language skills or their communication skills. These skills must be relevant to the inspection at hand, and the performance of the non-employee perhaps coming around on the walk around has to be such that it won't interfere with the overall operations of the business or the inspection itself. Overall, OSHA believes this makes inspections fairer, more balanced, and if you think about it, it could actually make them more balanced for both the employee and the workplace, because if you think about it, adding some criteria to who can come along as the non-employee, it may not be it's kind of a Northeast way of thinking, but it's gonna be like my cousin, unless your cousin's somebody very special who meets these qualifying factors. You're not just going to call in somebody randomly to come around with you on an OSHA inspection. It's going to help the employee, but it's also going to help the employer as well. And in the context of the real world, we do like to see rules that help both sides. So.
Awesome. Well, I can tell everyone from personal experience, and I'm sure many of our attendees know this, that workplace safety should be close to the top of the list of items to keep a close watch on and constantly maintain. Here at WorkWise Compliance, we have both in-office and virtual workers, and it's important to make sure that everyone is working in a safe environment. We don't want to give OSHA a reason to do any in-house inspections. So Jeff, let's wrap up this section on workplace safety.
Sure. Well, finally, the DOL also announced changes to the structure of OSHA's regional offices, and these took effect beginning in May. These changes are designed effectively to direct better regulatory resources, make OSHA more resilient, make OSHA honestly easier to find, and assist employers by allowing for easier reporting and contact procedures. The major takeaways from the change announcement involved renaming all OSHA offices from number designations, which they used formerly, to geography-based designations, which are going to rely, generally speaking, on how the metropolitan area covered by the particular OSHA office, generally speaking, how that metropolitan area views itself. And I just think about this in terms of sports teams, because as a Vermont Law School graduate, I heard an awful lot about the Boston teams when I was up there, and that's kind of how the whole Northeast anticipates itself, kind of as the Boston region. So what was once called Region 1 up there in the Northeast is now going to be called the Boston region. What was once called Region 2 will be the New York City region. Region 5 will switch to the Chicago region, and so on with the other major metropolitan areas throughout the country. Additionally, Regions 9 and 10 will merge into the newly named San Francisco region to improve operations and reduce operating costs over there on the West Coast. Additionally, a brand new OSHA regional office is being created in Birmingham, Alabama, which will oversee OSHA's operations in Alabama itself, as well as the states of Arkansas, Kentucky, Louisiana, Mississippi, Tennessee, and the Florida Panhandle. This newly created office will be called the Birmingham Regional Office, and it will address the area's growing worker population and the hazardous work that's done by employees in that region in some of the sectors identified by OSHA as being very large in that region, which include food processing, construction, heavy manufacturing, and chemical processing.
And sorry, thanks for breaking down the latest legal updates surrounding workplace safety and health, Jeff. Next, could you cover any updates involving equal employment opportunity, harassment, and discrimination?
Sure, Dan, big changes here. Before we get into the specific section, however, I want to remind our viewers that the laws enforced by the Equal Employment Opportunity Commission, also known as the EEOC, apply to businesses with 15 or more employees. However, many states have created and enforced similar or identical laws to the laws of the EEOC, and these apply to companies with as few as one employee. Since that's the case, the information we're about to discuss in this section may apply to smaller sized businesses as well as larger ones. On April 17th of 2024, the United States Supreme Court delivered a ruling in a case called Muldrow versus City of St. Louis, which is expected to reshape the landscape of Title VII litigation. As a refresher, Title VII prohibits employment discrimination based on protected classes like race, color, age, religion, sex, gender identification, and gender expression, as well as a few other protected groups. This landmark decision removed the long-standing requirement, upheld by several federal circuit courts of appeal, which required plaintiffs in discrimination cases to demonstrate something called significant harm when they're trying to seek damages from their employers. The Muldrow case, on the facts, involved a police officer who was transferred to a different role within her police department in 2017. Despite maintaining her rank and compensation, the officer experienced a transfer that required her to wear a uniform, work occasional weekend shifts, oversee neighborhood patrol officers, and give up access to an unmarked police vehicle that she'd previously been able to drive home. Many of the added tasks and many of the things taken away were new developments in her day-to-day work situation. Alleging gender discrimination, the officer sued, contending that her transfer was in fact a discriminatory practice motivated by her gender. The lower courts found that these actions were not significant enough to be considered a Title VII claim. The Supreme Court, however, disagreed. According to the nation's highest court, Title VII simply forbids discrimination based on being a member of the protected classification. It does not have to result in a showing of significant harm, or some other courts called it substantial harm. But going forward from the Supreme Court decision, even some harm could prove a cause of action for aggrieved employees. The Muldrow ruling could be imagined in the context of some place besides a police officer working in a city, because although the men and women of law enforcement are a very important group in our society, they don't represent necessarily a very massive group of people in our society. It is one particular type of employment. But let's imagine this instead in the context of some other people who maybe represent a larger sector. And these might be restaurant workers, office workers, and the many other types of professions that our attendees might be involved in or aware of. Take, for example, another example, a server in a restaurant. The server might have tried to bring a discrimination claim previously if they refused a supervisor's romantic advances, and then suddenly they were given fewer desirable shifts as compared to their fellow servers. Pre-Muldrow, these might not have been enough to reach the harm threshold that was required by the law. But going forward after Muldrow, if the server could prove that the change was based on rejecting a manager's romantic advances, this could be enough of a showing of harm in a title discrimination lawsuit to bring it all the way home. The office context is an even broader one and could include previously uncovered things like not having a birthday acknowledged when other office staff are celebrated, or not being invited to join a team they were qualified to be on, or not being asked to go on a workplace retreat that their other coworkers who were similar were invited to and went on. It's really going to be a much broader scope now, and employers will have to be careful not to take any actions or deny anything to any worker based upon discriminatory motivations. Training from the top down is going to be essential as companies count on their various levels of managers and at the same time are accountable legally for their managers and their employees' actions.
All right. Thanks so much, Jeff. Let's see here. I'm going to go ahead and skip our next poll so we can get it moving so we can leave time for some questions. So can you talk about the revised harassment prevention guidance that was released earlier this year by the EEOC?
Sure, Stephanie. In April, the EEOC published enforcement guidance on harassment in the workplace. By making this resource on legal standards and employer liability for harassment claims available, the EEOC stated that it hopes people will feel safer on the job and that employers can create more respectful workplaces. In particular, the agency is hoping to protect individuals who are particularly vulnerable to harassment, along with workers from traditionally underserved communities, to protect them from employment discrimination. The guidance includes over 70 practical examples illustrating unlawful harassment and including hypothetical situations involving older workers, immigrant workers, and survivors of gender-based violence. It also describes how employees may be subject to illegal harassment from coworkers, supervisors, customers, contractors, and even third parties. In addition, the guidance addresses the growth of virtual work environments and the increasing impacts of digital technology and social media on the various ways that harassment can occur. Employers should review the EEOC's guidance to ensure that the examples of harassment included within this resource are not occurring at their particular workplaces. A link to the guidance can be found in today's 2024 Mid-Year Employment Laws Update e-guide.
Thanks, Jeff. And before we move on, I'd like to encourage everyone in attendance to follow our blog at blog.personnelconcepts.com for any labor law news and updates that we post to regularly. We will put a link in the chat window so you can bookmark that. Now, Jeff, are there any other EEO related subjects you want to discuss?
Yes, Stephanie, sure. There's one more I'd like to touch on in this area. It's called the Pregnant Workers Fairness Act. It became law in 2023, and it places new obligations on employers to provide reasonable accommodations to qualified employees or applicants based on known limitations relating to pregnancy, childbirth, or related medical conditions, unless the accommodation would cause an undue hardship on the business. An undue hardship means that the accommodation would be overly costly, overly extensive, overly substantial, or disruptive to the operations or the economic structure of the business. The EEOC immediately began accepting charges under the law for violations last year in 2023. The EEOC, however, did not issue at that time final rules or any guidance to how to implement the PWFA until this year in April of 2024. The guidance, like the previously mentioned workplace harassment guidance, is going to include practical and real-world examples for employees to maintain a discrimination-free workplace, keeping in mind pregnancy-related accommodations. The EEOC's final rule and the interpretive guidance that accompanies it became effective in June 2024, and it can also be found within the very handy 2024 Mid-Year Employment Laws Update e-Guide, which is being provided today for further review and consideration.
Thanks, Jeff. And as we start winding down, are there any other recent updates you'd like to touch on?
Yes, Dan, I'm going to go through a couple other items, and I'm going to go through them kind of quick as the summary points, because these are available in the 2024 Mid-Year Employment Laws Update e-Guide, which is being provided. So we'll go through these kind of quick. These are the highlights of the highlights. First, the DOL joined other federal agencies in calling for fairness, equality, justice, and compliance when using newly developed artificial intelligence software in the employment processes. Specifically, the DOL requires that any AI utilized in employment-related actions comply with all of the other laws that are the federal laws related to anti-discrimination and other important protections. Secondly, in March, the U.S. District Court for the District of Alabama declared the Corporate Transparency Act unconstitutional. This law had become effective a few years earlier, and it was designed to crack down on violations of business disclosures of who the owners of the business were to root out things like terrorists and other criminal activities. The district court, however, found the CTA was overbroad in terms of the power exercised by Congress in creating it, and this is actually a win for small businesses, as where this ruling is applicable, it lessens the required reporting obligations. Next up, in February of 2024, the DOL's Benefits Security Administration released an overview of its 2023 enforcement activities, detailing that a total of $1.4 billion was recovered for workers in the fiscal year 2023. This is important because it sends a signal to employers that the DOL is very active in enforcement of employee benefits, and that this can be very expensive if there's non-compliance that occurs. It's sort of like a bragging rights, but also helpful data that say this previous year, this much money was collected. So we're a very active agency, and we're taking this very seriously. In March of 2024, the DOL released a new resource to help boost the participation of people with disabilities in competitive employment. Another way to say that is in equal employment opportunities. The new law creates a resource called the Competitive Integrated Employment Transformation Hub, which is a clearinghouse that brings together federal government resources regarding practical guidance, policy information, and evidence-based practices for people living with disabilities and underserved populations to reach out to the agency. Also, the EEOC launched something called the REACH Initiative, a new multi-year effort to ensure that the agency's outreach and education efforts effectively reach workers identified as being traditionally underserved. Plans for the REACH initiative include holding in-person and virtual listening sessions to teach workers more about the EEOC and its protections and its enforcement, as well as identifying existing barriers to reporting discrimination and soliciting recommendations on better ways to serve these traditionally underserved populations. Employers that work with folks from these communities should be aware that the EEOC is ramping up investigation efforts as well to try to prevent additional occurrences of workplace harassment and the arising discrimination claims. And this could mean more fines, more penalties, and more lawsuits. Finally, the Internal Revenue Service, the IRS, is updating its guidance regarding digital assets. This is very important for people who deal in the cryptocurrency world. Beginning this year, digital assets are statutorily required when being reported to the IRS to be considered property and not currency. Providing further explanation on this, the IRS defined a digital asset as something stored electronically that can be bought, sold, owned, transferred, or traded. Digital assets that many people in the business world are familiar with include virtual currencies, cryptocurrencies, and the various subdivisions of cryptocurrencies, which include such big names as Bitcoin, stablecoins, and different types of non-fungible tokens or NFTs. All employers must report digital asset transactions, so when they buy or sell or get paid in cryptocurrencies, whether or not these result in a taxable gain or loss.
Thanks so much, Jeff. And as we close out the information portion of our webinar, can you let us know which states had minimum wage increases this year?
Certainly, Stephanie. We've got a grand total of 28 states and also Washington, D.C. and Puerto Rico that saw minimum wage increases in 2024. Most of these increases went into effect in January, but as we said at the beginning of our talk today, a lot of increases sometimes go into effect also in July. So look at the beginning of year and mid-year. The states and territories that had increases as of July 1st are shown on this slide being presented by WorkWise. WorkWise Compliance is also providing its updated minimum wage map as an attachment that you can download through GoToWebinar during this session.
Thanks,
All right,
Dan.
thank you for covering these minimum wage changes, Jeff. And the time has come for us to connect with our expert. So we're going to jump into our live Q&A session.
All right, thanks, Dan. Thanks, Jeff. So to participate in today's Q&A session, I just want to encourage everyone in attendance to submit questions using that question feature and GoToWebinar. You can also ask our staff questions using the chat window, and we'll get through the most relevant audience questions now. But just know all unanswered questions, I know we don't have a lot of time left, but they will be submitted to Jeff for responses and sent to you via email. So keep them coming up till the end, okay? We'll keep Jeff busy. So with that, let's just let's look at our first question, and we'll put them on the screen here so everyone can see it. So Jeff, putting you on the spot, our business is in California, and our state's overtime exemption salary threshold is higher than the new federal level. Do we need to do anything under the new rules?
There's always going to be an interesting question, and California is a good state to think about it in terms of, because California has traditionally had a variety of laws that have been out of sync with the federal laws. These have related to so many topics that they're broad to name. Marijuana was early in California. Auto emissions for cars was very early in California. That's the California emission standard that pretty much nationally all cars have to follow. I talk about those tangential things to sort of explain the very broad, quick concept of something called federal versus state preemption. Generally speaking, if a state does something that's out of line with the federal government, there's always the possibility for the federal government to go ahead and enforce. In terms of the states being more strict than the federal government, that applies, and the states the state businesses have to follow the more strict laws. To go the other way, can the states get away with following any less strict laws than the federal government? The answer is potentially yes. I don't want to be held responsible for saying it. We've got our disclaimer, but the issue is that if the federal government decides to try to enforce its rules, for example, the higher threshold, or rather the lower threshold that I guess this would create, if the federal government steps in and tries to enforce that, they're ones enforcing agencies, it will be able to do that regardless of the state's laws. The states are not allowed to pass laws that are less restrictive than the laws of the federal government, only more. So I give you that general guidance, and to say that if the federal laws are tougher, follow the federal laws or face possible risks of noncompliance from the federal agencies. And those can staff up or staff down based on the political climate. But generally speaking, it's always better to follow the stricter federal laws.
Yeah, we see that with like minimum wages and everything too, right? Let's get another
Right.
question on the board here so we can get through a few more. Regarding non-compete agreements, you stated that employers must notify. How can that notification occur? Can it be verbal, via email and writing, a posted notice, or a newly signed agreement?
That's a great question. I'm going to strike verbal right out. Don't do it verbally. And the reason is we want to create a record of compliance here in order to make sure that the company that's giving this has a defense. Certainly, if anybody says they didn't receive this notice, you would not want to have to build up and prove to the agency or the court looking into it that somehow verbal notice was given. So do not gather everybody in a room and say it out loud and hope that somebody's got their phone out or you managed to record it. Although that's not the worst way if you have to do it that way. But no, it needs to be in writing. The FTC and through WorkWise can help you get a sample outreach message that you can send out. If you have a process by which you email your employees work memos, or you have some sort of internal memo process, maybe you still hand things out, maybe you do it over email, maybe I have clients that use Google Drive and the employees sign something that says they've routinely accessed certain HR policies in Google Drive. The best way to do it is to send it out in writing and to receive affirmative confirmation of its receipt and understanding. The second best way to do it is to send it in writing to everybody. And certainly the third and worst way to do it that I do not recommend is to try to do it verbally. So do it in writing. Use the guidance that's been provided, because that guidance is very clear and very specific, and it will serve as a defense if your business is called out by an agency or by a court or by a lawsuit, by way of a court that you didn't comply. Do it in writing.
All right, thanks for answering that for us, Jeff. And again, we'll get all the answers to all your questions in writing from Jeff and sent to you via email as well. Let's get another question on the board here. If our background checks do not include financial or credit information, do we still need to provide disclosures that we conduct them?
It seems that under the new federal rule with the what has to be disclosed, it seems like you have to disclose not what you don't do, but what you do. So if you don't conduct financial background checks, I'm going to say you don't have to disclose that you do conduct something you don't disclose. There's no negative implication required. So what I'm saying is that you have to disclose what you do conduct and where that could lead to an adverse action. So if you're going to look for information that could be used against an applicant or against an internal worker in terms of something like a promotion, if you're going to ask for the approval in the background check to look at their private information, and then that could be used in an adverse decision, which is any negative decision relating to a term and condition of their employment, including their hiring, their promotion, or their firing. If you're going to do that, you have to disclose the full bevy of information that you're going to be looking into. So not if you're not going to look into it, but if you're going to look into it, it's the looking into that has to be disclosed and in relation to the adverse action. There's no getting in. It's very much a disclosure statute. There's no getting the information and then secretly deciding what to do with it. This law is going to make you disclose what you looked at and what it could ultimately be used to do with regard to the employee.
Gotcha, that makes sense. Thanks, Jeff. We're running out of time here. So again, all unanswered questions will be forwarded to Jeff via email. His responses will be sent to all attendees in the coming days, along with a link to review this webinar. So thank you so much for everyone who submitted questions for today's session and for Jeff to answering them for us. I also want to remind all attendees that you can access our 2024 Mid-Year Employment Laws Update e-guide, which has links to all of that legislation, the 2024 minimum wage map, and today's slide presentation attached as handouts here in GoToWebinar. Jeff, can you leave us with the key takeaways on mid-year employment law updates just across the board?
Sure thing, Stephanie. Now, I'm just going to put numbers in front of these because it's going to make it easier for people to keep track as we go. Under the FTC's rule that bans non-compete agreements and non-compete clauses, existing non-competes for most workers will no longer be enforceable after September 4th, 2024. Beginning then, employers must not enter into or attempt to even enforce previous non-competes. Employers must also notify workers, other than senior executives bound by an existing non-compete, that they will not be enforcing the non-competes against these persons. Number two, with the passage of the new overtime rule, employers must ensure that they are following the new thresholds that took effect on July 1 and the new thresholds slated to take effect on January 1st, 2025. Number three, to comply with March's workers' misclassification rule, employers should do a top-down examination of the job responsibilities of their current employees and any future hires to determine proper worker classifications, avoid misclassification, and compare the facts and circumstances of the work situation to the reestablished multi-factor test. Number four, even with the Supreme Court's recent ruling on significant harm, there still can be confusion out there as to significant harm, substantial harm, or some harm. Employers should continue to follow the laws dictated under Title VII, but bear in mind that now harm has been a much, much more lowered standard, and they should take a look at their practices to ensure that they're taking no action in their workplace that could lead to charges of discrimination. Number five, all employers should review the updated EEOC guidance on workplace harassment prevention to refresh their knowledge of harassment and discrimination prevention laws and ideas on proper prevention methods. Some great practical guidance out there from the EEOC. Remember, many states have similar or identical harassment laws to the federal EEOC regulations, and these mean that almost all businesses could be affected. There wouldn't be exclusions based on size. Even a business with one employee, could be affected by some version of these laws.
Jeff, thanks for the key takeaways. Before we end today's session, I'd like to remind everybody that all attendees will receive a follow-up email with a certificate as proof of attendance for today's webinar.
Yes, thank you so much. So this concludes today's webinar. Thank you for attending our presentation. We hope you found the information provided during the session helpful and informative. And thanks again to Jeff for participating as our expert guest attorney. We look forward to continuing to work with you on future presentations.
Well, thank you, Dan and Stephanie. It was my pleasure. Thanks to all.
All right, and folks, if you enjoyed today's session, we invite you to view past webinars on demand within our digital library. Simply click the link in the chat window and log in using the customer or account number or email address associated with your account. If you're not a subscriber and you do not have access to the digital library or would like more information on WorkWise compliance, we can assist you and your business in employment law compliance. Please contact one of our customer service representatives today. The phone number is currently in the chat window.
And to all of our attendees, thank you for choosing WorkWise as your provider of labor law compliance solutions. We would like to ask you to please participate in the short survey that will become available at the end of this webinar session. Have a good afternoon, everyone.